Two common contract interpretation issues that arise on the bar exam are the parole evidence rule and, in contracts for the sale of goods, the knockout rule. At common law, the parole evidence rule posits that a court generally may not consider extrinsic evidence to change, contradict, or add to the unambiguous terms of an integrated written agreement. Extrinsic evidence is evidence outside the four corners of the written agreement. This type of evidence includes other oral or written agreements, negotiations, and correspondence, as well as the parties' dealings with each other. Evidence arising after the contract's formation generally doesn't fall within the parole evidence rule, though evidence arising before or contemporaneously with the contract's formation does fall under the rule. An agreement is integrated if it consists of a writing or series of writings forming one transaction and embodies the final expression of the parties' intent concerning the contract's subject matter. An agreement may be fully integrated or partially integrated. Even if the agreement is fully or partially integrated, courts may consider extrinsic evidence to determine whether the agreement is integrated, clarify an ambiguous term, which is one susceptible to multiple reasonable interpretations, decide whether there's a valid defense to enforceability, determine whether a contract was ever formed, grant or deny a remedy for breach of contract, or establish a later modification to the contract. Under the Uniform Commercial Code, or UCC, if the parties' writings agree on a term, or if the agreement is integrated with respect to the term, then extrinsic evidence is inadmissible to contradict the term. Extrinsic evidence is, however, admissible to explain or clarify the term, regardless of whether the agreement is partially or fully integrated. If the agreement is partially integrated, then extrinsic evidence is also admissible to supplement the agreement with consistent additional terms. Under the UCC, the three types of extrinsic evidence are the party's course of performance on the specific agreement, the party's course of dealing in prior similar transactions, and trade usages. The bar exam likes to ask students about conflicting pieces of extrinsic evidence and which source of extrinsic evidence might control on a given question of interpretation. In general, course of performance evidence gets greater weight than evidence of course of dealing, which in turn gets greater weight than evidence of trade usage and custom. When these sources conflict, courts follow the same hierarchy. Recall that, unlike contracts governed by the common law, a valid contract for the sale of goods can form even if an offeree's acceptance isn't identical to the original offer. The mismatch between offer and acceptance can create interpretation issues. Because the acceptance contains terms in addition to or different from those in the offer, questions can arise about what exactly the parties agreed to. Whether additional or different terms in an acceptance become part of a contract for the sale of goods depends on whether the parties are merchants. A merchant is someone in the business of selling goods of the kind at issue in the transaction, or who by occupation holds herself out as having specialized knowledge of the goods or the type of transaction involved. If at least one party isn't a merchant, then the contract will contain any additional or different terms in an acceptance only if the offerer expressly agrees to them. If all parties are merchants, then whether the non-matching terms in the acceptance become part of the contract depends on whether the terms are in addition to what's in the offer or different from what's in the offer. Additional terms weren't part of the offer at all. In other words, the offer is silent on additional terms. In contrast, different terms are addressed in the offer, but the offer and acceptance aren't identical. Any additional terms in an acceptance automatically become part of a contract involving merchants, unless an exception applies. If an exception applies, the additional terms become part of the contract between merchants only if the offerer expressly agrees to them. The exceptions are: the offer expressly limits acceptance to the offer's terms, the additional terms materially alter those in the offer, or the offerer objects within a reasonable time. If all parties are merchants, any different terms in the offer and the acceptance are dropped or knocked out of the contract. This is called the knockout rule. Any gaps from the removal of differing terms are filled by implication. The omitted terms can be implied by fact, with evidence of trade usage in the relevant industry. Alternatively, the omitted terms can be implied by law with the UCC's gap filler provisions. The UCC supplies a number of default or gap filler provisions that will supply a missing or omitted term. These provisions frequently come into play on questions testing the knockout rule. For example, if the contract is missing a price term, the contract price is a reasonable price at the time for delivery. Unless otherwise agreed, the place for delivery is the seller's place of business or his residence if he has no place of business. Similarly, payment is due at the time and place at which the buyer is to receive the goods.